Good evening, good evening. It's Tuesday, June 7th, and it's just a half a minute after 7 o'clock. And we're going to get this work session underway. This is ruled a work session because last Friday we received the item that we had been waiting for, and that is the response from the three state officials. The three state officials who had reviewed the preliminary report that was sent in back in April, and they had 45 days to respond to it. The 45th day happened to be Friday. And as time passed on Friday, I thought, well, I guess it's not going to be here. So we even contemplated canceling this meeting because we wouldn't have anything to which to react. However, somewhere around noontime or a little after, we got the long-awaited thing, and this preliminary report of ours has been reviewed by three different individuals. One is the Attorney General, second one is the Secretary of State, and the third one is the Commissioner from the Department of Revenue Administration. There are copies here for all of our guests, and if you don't have one yet, please feel free. I think it's the the third one over. When I looked at it, and at first I thought, oh dear, this is a glass half empty. And then I thought, oh, Betty, grow up. And then I thought, well, no, this is a glass half full, because there are some things that have been approved. There is no objection to them. There are other things that have been objected to, and we need to figure out how to go about this. And so tonight is the start of that process. We also have next week on Tuesday already saved here and elsewhere for us to continue our work. So, are there any questions about what we're going to try to do tonight? It's called dig in, put your feet flat on the floor and straighten your backs, because we're about to go at it. However, we have something easy to do first, and that's the approval of the minutes of the May 10th meeting. And I will ask if there are any errors, omissions, corrections of any kind that anyone would like to make to those minutes. And if not, we'll take a motion to approve.
Motion to approve.
Second.
All right, it's been moved and approved. Those in favor will say aye, please.
Aye.
Are there any abstentions? Any negatives? None of either one. And so we can check 1 and 2 off. And we are really cruising, aren't we? But now we get into the nitty-gritty. Bill, are you the guy who's going to lead the band or the orchestra or whatever we are?
Well, I think what we could do is walk through it.
Okay.
And then we also have counsel here, legal counsel to the commission, who is reviewed this as well. And we may want to ask him to offer his thoughts on some of the stuff too.
I want you to look at my sheet. It is underlinings of red and then underlinings of green, so that I certainly won't get fouled up as I look at their responses. And yes, I believe that it probably is a very good idea, because not all of us are lawyer people. And if we have read that, and you didn't have much time to read it, I know, except that we wanted it in your hands. And so...
I would just go through it first.
Absolutely.
And put it on the table.
Okay.
So the letter is June 3rd of 2022. It's from the Attorney General's office, representing the 3 reviewing agencies of the state. Our First Amendment proposal, as you'll remember, addressed, had a charter commission section that would require the school board to adopt regulations and a policy, a resolution and a policy that would require candidates for school board and candidates for future charter commissions, whenever they might be held, to file information regarding campaign expenditures and campaign receipts. The letter of the AG's office objected to that proposal to try and bring more transparency to elections, for school board. Their logic, as they stated, is that there was no statutory provision that affirmatively authorize school districts to impose campaign finance provisions. And therefore, the statutes are silent. And they said, they conclude that what that silence means is that we did not have the powers of Charter Commission to recommend an amendment that would require the school board to put regulations in place. I won't discuss it yet, but just walk through it.
You don't want to do.
Oh, you want to go? Let's
We should do it one
start
at a
that
time,
one.
shouldn't
Perfect.
we? So they go a little further than that, don't they? Because they say that RSA 31 has some specific provisions that make the provisions of the statute applicable to school districts, and then some that specifically exclude school districts. In other words, make those provisions not applicable to school districts. So their position seems to me to be that the only manner in which a school district could adopt regulations dealing with campaign finance, in effect, is through RSA 31. Do you read it that way as well?
I think they're looking in 31 for affirmative language.
And there is affirmative language in 31 that deals with towns.
Yeah.
Why? Yes, I agree that there are sections that you take their logic. You wouldn't have to put those provisions in excluding, saying they're not applicable to school boards unless there was some reason to make them not applicable, this being one, but that RSA 3139 doesn't say it's not applicable. So I guess the argument would be RSA 31 is not the only authority that might vest school districts with only statute that might vest school districts, or for that matter, is a statutory authorization required at all, right? So I think we got to push back on this one a bit.
Well, I think there's a great question as to how we might push back. And there are options that we have available to us as a Charter Commission, and again, very legal options. And even though a couple of us on the commission are lawyers, in our capacity sitting here, we're members of the public who've been elected to these positions, I do think it'd be appropriate to ask those kind of legal questions to our counsel.
Isn't their argument essentially this as well? That, let's just say we gave up on this, and we called up the superintendent of schools and said, we think it would be smart if the school board for its elections adopted this type of provision. I read this letter to say they can't do that.
Without getting into the legal side of it, but I was talking with Tracy separately before the meeting, the policy side, as a matter of policy, the conclusion you just said makes 0 sense at all. It seems hard to believe that the legislature intended a structure where towns, which are municipal systems, are empowered to impose reasonable campaign finance restrictions, but school districts all across the state, which do arguably the most important function of the public sector in New Hampshire, of all of the total amount of money spent in the state of New Hampshire, state and local, over a third of it is in public education. It would be stunning to me if somehow the conclusion is that it is against the law for a good school board to impose a requirement.
If their logic was the only way you can do it is through RSA 31, then there'd at least be an argument that a school district couldn't do it. But, I mean, this goes back to Learned Hand's comment that we shouldn't be required to make sense out of every piece of gibberish passed by legislatures, but, you know.
I mean, I fully think that this is, if we're going to push back on anything, this is a hill I would go die on, because in the world that we live in and the way things are, I mean, my kid has 10 more years in the school district. You know, it personally affects me. I mean, the statute doesn't say it's illegal, so,
It's just silent.
You're right.
yeah. So how, just because it doesn't require it, I guess that's the opinion I would want to ask our attorney.
Yeah, come on up.
We should bring them up.
Yeah, I'm sorry.
Thank you.
I have a lot of
Sorry,
questions
you're
for
not
him.
a spectator, you're a player.
I'm sort of ready.
Yes.
Got his guns on. he's
Yeah.
ready.
So
And just to clarify for the record, you're Jim
I'm Jim
O'Shaughnessy.
O'Shaughnessy.
You're with the law firm?
Yeah, I'm with Drummond Woodsum.
And you have been engaged by this charter commission as our legal counsel.
Yes.
Completely consistent with the statute.
Yes.
And we think that's very important
Yeah.
and proper.
And I hardly ever make a mistake, so I am shocked at. So I anticipated that being the hot issue, so I poked around a little bit, did a little research, and I think it's helpful to understand a little bit of background. So RSA 194 is the statutory chapter that deals with the general powers and duties of school districts. It's a very old statute. It's really the original school law is RSA 194. The counterpart on the municipal side is RSA 31. RSA 31 is the chapter title is Powers and Duties of Towns. So over time, RSA 31 has been amended in various ways to have provisions regarding trust funds and a whole variety of places where, because there's no counterpart on the school side, they've added language in there to make it clear that this provision applies to school districts. The general authority in RSA 194, it's really so old, it really says nothing about campaign finance, and I'm not sure when the last time that provision was ever amended by the legislature. It's generally been seen as, like, school districts have sort of broad powers to manage the prudential affairs of a school district, and the general rule is you have whatever authority is either implied or inherent in that authority given to you under 194. So that's the legal argument you really have to make. A, that we have inherent authority as a school district that runs elections to do this. We don't need specific legislative authority. That's one argument. The other argument, which is you get it in sort of a roundabout way, which has really frustrated me throughout this whole process, is that the Concord School District was a legislative charter. Like, you existed under a legislative charter. You were not created at the turn of the century like all the other school districts. You have always been unique. In 2011, the legislature adopted special legislation to authorize you to adopt a municipal charter under 49B. The Municipal Charter Law only allows cities and towns to adopt municipal charters under 49B. So one of the arguments I don't want to be too glib about it, but I really think there's an argument that if we have authority to adopt a municipal charter under 49B, then we should be treated like a town or a city. I don't know how the state can say we're like a town or a city in this way, but we're not in this way. I think it has to be one way or the other. And everything else is just really good public policy arguments that you both were making. I agree with all of them. Process-wise, are we going to, I don't know if they're listening, are we going to be able to sort of persuade state officials to do a 180 on this? And it's sort of typical of the state, not in a bad way, but they're sort of looking at plain language of the statute. It's where we're always trained as lawyers. What does the plain language of 31 say? What does it say? It doesn't say school district has that authority. And then they fall back without anything else on, canons of statutory interpretation, which is what they did here. And they said, well, it doesn't say school district here, it says school districts in other places, and we have to assume the legislature was intentional, and we can't assume that the legislature meant that provision to apply to school districts. That's basically how they reached the conclusion. I don't think they dug down deep. I don't think they looked at really the inherent authority, implied authority concept. And so just to back up a quick step, I don't want to talk too long, but we get into this conversation about what authority does a school district have a lot, and we've gotten into it a lot recently, because we are not a home rule We're not a home rule state. We are a state where the political subdivisions get all of their authority from the legislature. And a lot of times people get confused about what that means. So the question here is, can we make a good argument that we already have that authority? Or do you think we can make a winning argument that we really are a town or a city for purposes of the interpretation and application of 49B? Those are two arguments I think we could make. I'm not sure how far we'll get there, but that's my analysis of that issue.
Could you address Bill Glon's question, which was, assume we don't do anything as a charter,
Yep,
but the school board comes to a meeting
yep.
and says, this is a gap. We should really want to protect our elections. Would the school board have the authority?
It's the same legal
Same
issue.
legal issue.
It comes down to, if I was advising the board, I would say, look, you can do it, but there's a risk that someone could challenge your authority to issue that bylaw or that local ordinance. Now it's right here in writing. Someone could challenge it on the basis that it's an ultra vires act. You don't have actual authority to do that as a school district because you're not a town. You'd be really back at the same place, but someone would have to make an affirmative challenge to bar you from
What's
enforcing.
really interesting about this is that in proposed amendment 4, they make almost exactly the opposite argument. They take the position that, well, you don't have an annual meeting and it's not set forth in the statute, but plainly the school board has the power to do this. So, I mean, I get there's a slight distinction there, but what's crazy about their position is, this is a matter of very good public policy, right? So well, I don't know, maybe the AG's office would go to bat and go to the legislature and ask them to amend 3139 to cover this. But, from your point, Tracy, it's not just an issue for people who have kids in the school.
No, and I didn't mean to sound so
This is an issue for the overall
Yeah.
value of the community in terms of what might be down the road in terms of people trying to finance candidates for the school board.
And it's happening in other cities and other towns in the country, and we need to protect our school district from what happened in those. And I feel like even if we lose the argument, we have to fight this fight.
I couldn't agree more, Tracy. Go ahead, Nancy.
Well, can I ask a question, a process question? So if we decide that we do want to challenge this, are we basically going back to the same people?
No.
Or is there another audience that we have?
Yes, it's called a court. You'd have to file a petition, declaratory judgment action, whatever, get in front of a judge, and they'd schedule a hearing within 10 days of receiving the petition. So you'd have to make this argument to a judge, and they would have to rule in favor of the district. And you have a hearing within 10 days. I'm not sure what the turnaround time is in terms of an order, but that's the only process. And there's other things you can do, right? We could make phone calls and set up meetings and write responses or rebuttals and see if that gained us any traction.
Can I follow up on that? Because I think statutory, that's the route. And that route is, fraught with things like cost, time and uncertainty. But when you have a provision like this, I think it is worthwhile to have a meeting with the public officials who were part of this decision, have a group from our, representatives of our, just like we did of our commission, sit with them, look them in the eye, and say, are you saying that this is how you're reading the law, so that no school district in this state has the ability to provide reasonable, transparent regulations over elections? And if they look you back in the eye and say, yes, we're saying that's what we think the current statute is, then the next question is, we represent the city of Concord, which we're going to go out of our job soon, but we would like to make sure that we have your commitment that if the city of Concord and representatives and maybe of the School Boards Association were to seek a legislative amendment to make clear that school districts must have this authority to regulate elections fairly and transparently, we'd want to look them and make sure they didn't say, no, we'd oppose you. We want to get their commitment, because if we do, we're doing our job as a charter commission. And so I think that's less than going to court, but perhaps it's more effective. And the final thing I'd ask, Jim, with your practice, do you know how many other school districts? There's elections in places like Merrimack and in Bedford and in Portsmouth and other cities and Manchester where school issues are very controversial. Do you know if any of them provide any kind of campaign finance reporting?
I don't know. I mean, the thing is, all of those communities, especially the cities, run the elections for both the town and city side. So if campaign finance reporting is required, I suspect they require it for everybody, because it's a citywide election and you're running for a citywide office.
Or Merrimack, a town of Merrimack, I would wonder, or Bedford.
Not on the town side, because the school districts can't. I'm not aware of any school district that has a traditional annual meeting form of government that does require that. I don't know on the city side. But part of this.
Oh, yeah, because there's not an election. It's right at the annual meeting.
Yeah.
Yeah,
And
right.
on the city side, the city elections in cities are also the school district elections. You guys you're a separate entity, entirely separate. And so it really does, you are a hybrid, you're unique, and.
I mean, so that seems like an argument right there, that if you're in a city that the city's running the elections, you're allowed to have your school board finance and so it's a double standard. I mean, I don't know. I think we should do Bill's option. I also think we should force to court if we have to. Like, to me, this is really important.
Right, well, Bill, when you describe that option, it sounds like that would not affect.
It seems like a
this
long
year.
term.
It's a long-term solution.
It may not. You never know what happens. Sometimes officials are working under deadlines. They're not thinking through political ramifications and true policy ramifications. You never know. I've been in meetings with officials where they go, I missed that. We withdraw that. It's worth, for the reasons Tracy said, going into that meeting and asking the question.
But we can do both.
Yes,
Okay,
the court.
I'm gonna pull rank here.
You may.
We're trying to wade through all of these tonight, and so I think we've done exactly the right thing. We've discussed it, we've interpreted it, we've explored a few options, and I think I hear clearly, and I'm very much a part of it, push back. It's the right thing to do, and we need to find a way to do it. And so therefore, if there's no major objection, Bill, I'm gonna ask you to go on, so that we
I have
can.
one more thing. I'd like
Okay,
to
go ahead.
I would like to see, and we've had 2 school board members here, and I'd like to see them call a policy meeting and say that they are going to look at the policy for elections for Concord school board members, which we have a policy, and meet to discuss in an open forum if they were thinking of changing it so that when people run for this office, they have to do some reporting of their, follow those steps carefully and get it in place for the next election. And if someone files a charge and says that you can't do this, fine, but knowing what I know about how things run in the city, people would do it there.
Yeah, and I want to just
While
ask.
we were trying to do all of this.
I want to ask a question too. I'm not sure that it's worth the expenditure of time and money, and I don't know what the timing of this would be, Jim, for the city of Concord. Really going to pay this bill, taxpayers will, to fight this battle here as opposed to at the school board. I do think a nicely written op-ed to the Monitor that suggests that the Attorney General of the state of New Hampshire has opposed the notion that school boards should be required are not allowed to govern, to provide restrictions on campaign finance would be an interesting approach. I'd do it after the meeting, but I'd let them know that we're going to do it.
Pull out the eggs, get ready to throw.
I'd like to make sure that the Secretary of State knew this position was taken.
I mean, it's.
Because he takes different positions
I
in every
understand
other
their
case.
position, I understand the position that they're taking, which is that it may not be legal. I get that. I didn't read through all the statutory cites in the letter. I read through some of them this afternoon. They don't seem to have much to do. They're one-offs in almost every situation. So Jim, just let me ask one question first, which assume for the moment we wanted to file this petition. What's the timing of that relative to a requirement to get a final report?
Yeah, like, it's extraordinarily limited. We have a deadline of June 22nd. The hearing is scheduled in 10 days, so,
And-
and we're at the 7th already, so.
And you know, the problem with that is when, you have to tell clients, when you're involved in preliminary injunctions and immediate petitions, it's expensive. So we can come back and revisit that, but and Betty, I understand we spent a lot of time on this, but a lot of the issues that
Oh,
we're.
no, and it's probably one of the most important.
Well, but also this issue that we're discussing of implied authority versus explicit authority carries over into the other areas.
I mean, and I get that it's expensive, but at the same time, it's also expensive if your school board gets hijacked by a special interest group that starts doing damage and sets precedent. I mean, I think there's some things that are worth spending money on.
Yeah, but you have to know whether the game is worth the candle. And you have to know whether your legal position is sufficiently strong that you really have a chance of prevailing.
Well, I'm not trying to kick the can down the road. What we're trying to do is get through this, because we have another meeting scheduled for next week, and part of our agenda will be to set it up.
Eric's got a comment.
Eric, I'm sorry.
Two quick things is, to get this done, whether it's within what we're doing now in the Charter Commission or not, can we kick it back to the city and have it under their purview to, no, okay, that's an easy one. Second, how did we get where we're doing Charter Commission? What authorized us, and I don't need an answer now, to do campaign disclosures when we ran for commission?
That's right. We had to
Yeah.
disclose.
I think it's in the charter. I thought it was in.
It is in the charter.
It was.
I understand that, but what authorized?
How did it get
the
there?
charter? And why isn't it applicable going forward?
Not a bad point.
That's a great point.
That's
That
it.
needs a little tracing, and I have some ideas on that.
I think those are great. I think, actually, the discussion here is, I was looking forward to this group. I miss Tom. But Clint, not, having us not be the body to initiate a court proceeding that's costly, it's okay maybe if Clint's process that he laid out, which is the true representatives of this district are our elected school board members, they can discuss this and they can handle the issues of costs perhaps, and the balances for our taxpayers versus our,
Bill and I will represent you.
no.
So just to add to that point, the amendment was to require the board to adopt a policy regulating campaign financing. So if it doesn't exist here, it doesn't mean they can't still do it.
Absolutely.
So it's, you're also like one part removed, so it does, that's a completely
Well,
acceptable
we also, I
option.
take it we could also, although maybe the state would disagree with this, we could amend the charter to say that we recommend that the school board adopt this procedure.
Better
No.
to leave it.
It's
cute.
too vague for a vote.
So, I'm getting a little lost here in all these different options. What I'm hearing, I think, is that instead of doing a judicial hearing or a meeting, another option is to ask the school board to convene their policy committee and discuss making a policy about campaign finance reporting.
Exactly.
And deal with the potential fallout if there is any, but that will be on the school boards, that's the school board's responsibility, and therefore it would not be a ballot question.
Correct.
Yeah, I think,
So-
I think you can combine two. You wouldn't necessarily have to give up the meeting to
No,
try
you can't.
again in order to
Okay.
have that
But
process.
I have a question about that. If it's not in the charter, then a later school board could undo it and
Absolutely.
say, we don't have to do it. The point of it being in the charter is that we're protecting the taxpayers, we're protecting,
It's true.
I don't know, I go back to my, this is a fight worth fighting.
Well, I guess though, I go back to part of what Bill said is, I completely agree with you that it's, to me, I don't really care about the rest of them in comparison. To me, this is
Right.
the most important issue. But if it's not likely to be won in the traditional way that we would challenge it, then I would rather at least get it in as a policy and
Can we do it all?
See how it runs.
just because I don't want to come out with nothing is my concern.
Here's a suggestion. That we ask Jim to give us his opinion next week on whether, if we sued the state over this, provided this is enough time. No, it's gotta be now.
Yeah, so
3 days.
I don't think that would, I mean, no-
We have
What
to
you-
so
decide
this is,
tonight.
this is a
Let me
hole in
put you on
one.
a spot that every.
No, that's
client-
fine. I don't-
Every client puts every lawyer on. Do we win this or not?
But we don't
What
have
are
that
the
kind of
odds?
time. Tonight is when we would have to
Yeah,
decide.
but that's what I'm asking. What's, every client, I never put the odds higher than 60-40, let me just leave you there.
I would start with 50-50.
Me too.
Because I'm just negotiating them to, understand something. So what are the actual odds here? So I'll lay it out this way. We get this in front of a judge. It sort of gets emergency treatment, right? We want an expedited process. It's like a TRO. So we almost have to show likelihood to prevail on the merits. We have to show them that the state's arguments are really kind of garbage and our arguments are really good. I think to get most judges in New Hampshire to side with Concord because the state they have an argument. It's not.
But is it effectively a declaratory judgment proceeding? Because in an injunction proceeding, we'd have to show irreparable harm, which I don't know.
No, it's a DJ action, but it gets expedited
Yeah.
treatment by statute. And I think, I don't give it better than 50-50 because you're asking a judge on a very expedited basis to sort of issue a ruling that goes against, the state. And I think that's hard. And here's the thing. The state, I think, is geared up to appeal one of these to the Supreme Court. I just get that feeling after what happened in Manchester, right? You've heard we've heard the grumblings. They didn't appeal that case. So they probably would like to get some Supreme Court language favoring some of the positions they're taking. So I suspect they might even appeal that, and we would be in limbo. It would throw the whole process sort of into, well, what do we do then if we're in litigation and we haven't filed a final?
Yeah.
It's.
Well, you'd almost be better putting your efforts in getting the legislature to amend
Yeah.
this.
There,
Yeah.
and
Our
the school, if we think of the real path, Tracy, that really puts our strong policy position, which seems modern and appropriate, in place. The real steps are, we push for that meeting to put the state on notice that we think they really got it wrong from a policy, if not a legal perspective. We ask our school board as a charter commission, which we can do. They don't have to, but we can ask them as a body that has the best spirit of the school district at heart to consider a policy and consider what to do on this. And then remember, the school board under the charter has the power to put an amendment on another ballot. There doesn't have to be another charter commission to bring this up. That's there. And so really, I think what we've done as a charter commission, and we can be proud of it, we've identified the issue. We had testimony in support of this issue, making it a top issue. We followed the public input there. We really did it. We have put this issue on the front burner. We should, as a matter of diplomacy, have a meeting eye to eye with these officials and say, this is why we think you're wrong, and then have our elected school board consider this further. And I think that puts our best position morally, politically, and policy-wise forward.
I'll come to all of you with the op-ed, which we can all sign.
I'll put my name at the top. So next issue.
Well,
We don't have to discuss it. I'm sorry, go ahead.
no, are we done with it? I mean,
Well, we're
How do
not
people
done.
feel about that,
Well,
Well, we
Pat?
gotta talk to the
Maybe,
school board.
maybe we have to ask this question of the commission, whether we, at this point, want to authorize our attorney to file a petition. Because that has to be decided tonight in some respects.
right, that's what I was trying to get at, was I don't know, we have a timeline problem
That's a
here.
good question.
For the purposes of a discussion, I'll make a motion, which is that I move that we do not challenge the state's determination on this issue in court before the issuance of the final report, but that we do. So I think that's all we have to go. We don't have to go to the next
I'll
step.
second that motion.
Is a discussion.
Can we just clarify, so you're saying that we're not challenging it at court, but we would like to challenge it?
Well,
outside of court?
The only, we don't have to decide the scope of that meeting or when, it's going to be relatively soon.
Yeah.
But if we were going to file a petition to challenge this decision, it has to be done quickly.
Okay. I just
So,
wanted to clarify that
yeah,
that's what you're saying.
I'm not foreclosing any other options. It's only the question of, do we authorize our counsel at this point to file the petition?
Okay, yes.
Is there anyone who wants to speak to the motion?
Which is not to authorize her to file a petition.
If not, I'll call the question.
Okay.
The question has been moved. Is there a second?
Yes,
Bill
second.
did.
There's a second. And you understand what it is we're asking, okay? All those in favor of the motion will say aye, please.
Aye.
Those opposed? There are none. Any abstentions? There are none. Motion is passed.
I'm gonna make one more motion, and I hate to keep this going.
Good.
But my motion is that we recommend to the school board that they bring this issue before the policy committee with the idea of setting up a system for campaign financing.
Thank you. Is there
Do we have the authority to make recommendations
Yes,
apart from
we
the
do.
charter?
It's not a demand.
Second.
As long as you're not holding a big stick.
Yeah, it's not a demand,
I
it's a
second that.
recommendation.
Okay. Is there a second to that motion?
Yes, I'd
There's a
second.
second to that motion. I'm just gonna make a small comment. That's exactly why the people from the school board and the administration are here.
I saw that.
No, it's not my idea. I'll tell you, it's Gal Friday, Lyndon, who keeps thinking about all these things on a big wide plane, not television. And we're very happy that three of you can be here, and we know there will be more.
Thank you very much.
Yeah, no, and so this is exactly the kind of communication we want to have. And so if we're not burdening you too much, and if you think that, yeah, well, would you like to speak to it while we're on addressing the motion? This is Gina Cannon, who was the secretary of the school board.
So, yeah, I'm Gina Cannon. I am secretary of the school board, but more importantly, I'm the chair of the policy committee. So, we have already initiated this discussion. We haven't gotten very far. We've sort of brought it up. We knew this was a big deal for the commission, so we have initiated the conversation. We haven't gotten very far after that, but this is important to you all. I think the sense of the policy committee was that it was important to us, and so we are starting the conversation. My understanding is that it's a pretty complex ball of wax, but we're at least starting to try and figure out what we have to do. So I don't know if that helps.
I know
It
you've
does
been
help.
proactive on
But
this.
could I ask one thing, is that as complex as these issues are, they're also that important. And I'd like to see us make our first pass, if you guys agree that this is important, to make our first pass before the next election.
Well, I'm thinking, go ahead.
I don't know. We have some stuff on our plate that's required by the legislature for us to get into effect before school starts in the fall. So I don't know how much, I mean, yes, it's important, but we would have to get that into effect pretty darn soon, and I don't know if we have it on our plate to do that as well as what the legislature requires of us with the updates of all the things that they want us to be doing and changing and.
Well, what I would like to offer, and I probably wouldn't be me because I'm not the fact guy on the board, but that this group help in any way we can to
Yes.
get you through the system.
Okay,
'Cause we've done a lot of the research and we can help you.
okay, well,
And we'll
I
show up.
think that would, yeah, no, that would, I think, be helpful. You know, we'll have to sort of talk as a committee, how many times we want to meet between now and, you know,
Exactly.
the 1st of September, so.
We know how hard it is.
Thank you, that's what we're looking for.
Thank you.
Thank you, Gina.
So,
We
so,
need, in light of that, do we need to vote on the motion?
yeah, so the motion was to request that the school board.
recommend.
Yeah, and it's been moved and seconded, and we heard a response from the school board secretary, who happens to be the policy person, who I know has already been proactive on this issue, because we've had discussions several times. And are we ready for the vote? All right, those in favor of the motion made by Clint will say aye, please.
Aye.
Are there any nays? There are none, abstentions, none, and so the motion is passed.
I wonder whether we should, I'd like to make one motion to close this off, which is that the commission authorize, the last group that went was with legal counsel and then the lawyers with Kate Vaughn, Bill Glahn, and I, whatever group wants to be on this, including whoever wants to go, that we agree to authorize a meeting with the state officials to address our concerns about this campaign finance issue and put it right openly so they're not reading about it in the papers.
I agree.
Then they can read about it.
So that's my motion, to authorize that meeting.
Second.
Is there a second for that
Yeah,
motion?
a second.
From Nancy, thank you. Any discussion on that issue? Then we're ready for the vote. Those who approve of Bill's motion will say aye, please.
Aye.
Are there any nays? There are none. Any abstentions? There are none. That motion is passed as well. All set?
Yes.
And thank you, folks, again and again and again.
Just wanted to go.
We don't have to discuss number 2, do we, Bill?
We just say, just for the record, that on this proposed amendment 2, which is deleting obsolete references, there was no objection.
I bet they spent a lot of time on that.
Proposed amendment 3 were the clarification of the domicile requirements for our at-large and school district voting zone areas. There was one part of that, as I read it, that the state officials objected to, and that was the part that we discussed quite at
Ad
length.
nauseum.
Where if you're a person who lives in a voting zone and you run and get elected, from that voting zone, and then change your residence, if you go out of Concord, the seat is vacant, the state has not objected to that. But we had argued that there was some continuity benefit if the person who moved from one voting zone to another would stay in place until the next election. They've objected to that. And I guess that is on the table for any discussion.
Well, the way I saw that is, they're just going by the hard and fast rule, that if somebody moves out of a district, you stop right there. They didn't seem to understand or want to understand that the person would still be within the large district, capital D. And from the school board point of view, I find that what we were trying to do was make it convenient and hold on to experience and not have people in a roundabout, a temporary person until the next election and all of that. And so what we were doing was logical and efficient. They didn't see it that way.
It's another unintended consequence of going away from at-large voting to school zone voting.
You're being polite.
Well, to use Tracy's terms, this is not a hill I want to die on.
That's how I feel.
I think it's just.
With everything, I mean,
Yeah.
okay,
Yeah.
whatever.
But what,
I
what,
don't, you
what
know.
this does leave open is the question of how that seat gets filled, if it gets filled until the next election, which is some of the stuff we were talking about now. Except, I think that gets filled in the same way that district seat gets filled. In other words, it's at the next
And we've already
election period,
written-
not, it's the
written that.
next election period, not the election for that 3-year term. So,
Yeah, not a,
And I mean, the frequency of which someone's going to move who's just been elected to school board within the city, I think is low enough that,
Yeah.
again, we have bigger fish to fry.
yes, we do.
Can we just simply take out the offending parts
Yes.
and retain?
Yeah,
So for the final report process, what we're going to be doing is just eliminating the offending section and giving the same rule, which is the school board appoints
well, do we?
that
I don't
replacement.
think we say that, though, do we? Because that's not,
We do say it.
It's in the charter.
It's in the charter that we proposed, and they haven't objected to
okay,
that.
all right, good.
Okay, Lyndon,
I just wanted to point out that the board already has a policy. When a board member resigns, there already is a policy and a process that's set up. So I would just want to make sure that the commission took that into account when you take a look at this amendment.
I wish they'd been around for our 5-hour conversation instead of, you know.
Couldn't we just?
They were.
It's like Emily
Clint
Latella.
brought
What's
that
all
up.
this about violins on TV? Oh, never mind.
Do we even have to bother with anything with this one, because
Right, that's
again,
fine.
it's already in the existing charter, the replacement process.
The
Not
way
the
we
zone.
reframed paragraph 5 had a lot of improvements, like
Yeah.
changing, it used to say district, and, right,
Yeah.
exactly.
Yeah.
There was some non-clear language.
And they have not objected to that.
I lost track of that part, sorry about that.
well, what we would be doing is blessing a less efficient process, and one where there's constant in and out through the school board when someone moves. And we just thought we were regularizing it and making it more advantageous to have experienced school board members there. But if that offends them, fine. Do what we have to.
right.
And it retains the rest of it.
So, Madam Chair, proposed amendment 4, move on?
Wait, I think our attorney may have wanted to say
Oh,
something.
good, please.
Well, I've already taken liberty at sort of incorporating all the changes into the revised charter, so I just wanted, since we're gonna also still be on somewhat expedited, I just wanted to read the sentence, since we spent a lot of time wordsmithing sentences, get your feel for it, and then when we prepare for next meeting, I'll have something we all agree on. So it would say, this would be one condensed sentence, which speaks to filling vacancies. It would say, whenever a district or a school voting zone member ceases to remain domicile in the district school voting zone or otherwise vacates such office, because remember we added that clause?
Yeah.
The board shall declare the office of such person vacant and shall appoint a qualified person from the district or school voting zone as the case may be. I hate that, but what else do you say? To serve for the remainder of the calendar year, when the voters of the district or the school voting zone shall elect a replacement to serve for the balance of the unexpired term beginning in January.
Yeah.
How is that for a word
Well, let me
soup?
stop there and ask one question. Talk to me about that, serve for the remainder of the calendar year?
Yeah.
Because remember, they take place in January, they get elected in November, so we wanted to onboard
okay.
everyone on the
All
same
right.
day.
Technically,
That was like
they
the
take
final
office-
angel on the head of the pin that we
Yeah.
balanced.
Technically, they take office the first meeting in January,
So-
and that hasn't always been followed.
So that would be sort of how we combine those, so it's one long, really great sentence.
Okay, can you manage that? Gina?
Sorry, that wasn't what we did last time. So what happened was that as soon as the person was elected, they were sworn in. They didn't wait until January.
Right.
Correct.
So,
Right.
so you want to change that to, okay. I was like, wait, that's not what we did last time.
We talked about
Sorry.
that.
No, that's what I said, it wasn't done last time. And I had a major argument with a person in administration who claimed that they had a legal opinion, which we believe probably wasn't quite accurate. Okay, we're all set, right?
Right.
Great, yeah, thank you. Moving on.
Very good. If we could go to proposed amendment, should we close this out with a motion, though? That we accept, that's for the final good.
Yeah, there's
Sorry.
a process.
Proposed Amendment 4 was the school board stipend amounts, and this was just that we're going to require the school board to set annual compensation, as we wrote. The state did not object to it.
Essentially uncouple it from the city council.
Exactly.
Yeah, exactly right.
Any questions on that?
Proposed Amendment 5, this is probably not a surprise. This was the one that dealt with the appointment of school district treasurer and secretary. We had very good discussion about the policy reasons, why it's appropriate and important for the Concord School Board to appoint its treasurer, a very important officer, and the clerk. And we proposed an amendment that would say that. They have objected to that for the same reasons they stated 10 years ago. They've basically, though, said that's what the statute currently says, and they kind of apply. If the statute were amended to say otherwise, then it could be changed. So this fits right into a discussion we've already had on the first issue, which is that we maybe throw this issue into the meeting and make sure that they are, if we seek an amendment, they're not going to oppose it. That's special for the city of Concord, and make sure that these state officials understand the policy, which is a very good one. And I think we bring that up in the meeting, or not, depending on what they say. And so, finally, again, I don't think this is one that we need to take the sword on, because it's something that we did anticipate. They had tried it. We wanted to try and ask them to do the right policy thing again. They've declined.
I think the effort here is maybe starting with Mel Myler or someone like that, see if we can get the state representatives from Concord to sponsor this legislation.
Isn't that what
This one
happened?
feels like we have more time on. The
Yes.
other one
Yep.
feels much more
We definitely
pressing,
do.
and
Agreed.
this just,
But isn't
Agreed.
this what happened last time, that the treasurer issue lasted for a while, and it went through the legislature? And the way I heard the story is that there was a particular person in the legislature who very much was opposed to the appointment of a treasurer, because that just wasn't financially reasonable or desirable, and therefore it got shot down.
It was more the time. The timing was very
Okay.
tight.
Well, but-
Right now, we're talking about this right now, and the session is closed.
I know.
In that other time, it was very, very close to the end, and it didn't get done.
What's disappointing to me about this is sort of no level of analysis at all in terms of what we discussed with them, right? It's a rubber stamp of what they did before without paying any attention to the fact that this district is and has been different. There's no attempt to explain any logic behind that. But
They acknowledge in their letter that this district appointed treasurer and secretary and clerk for 80 years. And so I think, there's just an element here of, we understand their position, and it's really a legislative, they've made it a legislative question, I think. So I guess with that, the question is, I don't think, does anyone have any other comment?
I have one more.
Yes.
I'll just point out that I thought it was a little bit disingenuous when they suggested that the will of the voters have already spoken on this issue, when they adopted the charter that provided
Agreed.
for the election when they really weren't given another alternative or choice because of the AG's prior ruling. I thought that was disingenuous.
Please go ahead and adopt our charter in this form.
Yeah, so I thought that was not great.
It's certainly not consistent with the
Well,
history
it
of
looked like a
Concord.
Fishing expedition.
Oh, wait, sorry.
Go ahead.
I'm going to do the thing where I read.
Oh, yeah.
Well, I just want to know, is this all it's going to say now? So in the current charter, right, we're getting rid of obsolete language, which talks about, you know, the prior adoption and yada, yada. So now it'll just have section 3. It'll say the school district clerk and treasurer shall be elected for 3-year terms, period. That's all it's going to say. There's really nothing else in here. That's going to be the way it goes unless this is amended in the future in some other way if the
there
legislation changes.
Wait, are you reading 4A, Jim?
No, I'm reading like
June 5.
what's really 2 Roman numeral 3 now. After the school voting zone thing where it talks about voting zones, there shall be there's just a provision that says school district clerk and treasurer shall be elected for 3-year terms. Section 4 is a governing body, so I don't think it fits there.
And then, okay, so
It's hard to envision.
is there a
it.
4A in the charter that we were proposing?
Yes.
So that just is deleted?
Yes.
And then your section's right?
Yeah.
Got it.
Okay. And that's all it's going to say.
Jim, let me ask a question. Is there a procedure for removal of school board members?
A school board member?
Yeah.
You have to go to the Superior Court. I think it's in the RSA, I believe in the 40s, maybe 41.
So what's the procedure for removing?
Breach of confidentiality.
That's the only reason?
Yes,
Really?
yes.
Wow. Is there?
I mean, that's the only statutory reason. I'm sure if a board member engaged in some kind of egregious misconduct, you could go to Superior Court and use that other thing as a reason, but that's the only
Not according to the state.
well, yeah.
We interpret our statutes very
Yeah, it
liberally.
depends on-
Liberally. Well, so my next question was going to be, is there any procedure for removing the treasurer?
An elected treasurer, I don't know. It's really hard to remove elected officials.
Yeah.
My
It's-
question is, why is this a ballot? Why are we putting on a ballot if we're just continuing what we've been doing?
Well, we won't put it on the ballot, is that right?
That's what, we're not putting this on.
No.
Shouldn't put it on the ballot.
No, it's just a cleanup of,
Oh,
so the
okay.
other stuff is the obsolete language, and what will
Okay,
remain
I
is
just
just that
checked.
really,
Yeah.
Straight
I'm just
sentence.
confused as well.
I
but-
just-
yeah. I just want you to know that that's all it's gonna say. It's gonna be one sentence
Yeah.
on that issue, and all the other stuff we had already proposed deleting as obsolete.
All right. We get to Madam Chair,
Go
the
ahead.
last one.
Number 6.
Proposed Amendment 6. As you'll remember, we proposed that instead of stating all of that gobbledygook, some of which had been superseded by subsequent legislative action, we would refer to RSA 49B, which is, as our attorney says, for cities and towns, but the legislature expressly authorized us to rely on it. And we had.
And allowed us to create exceptions to it in the last charter.
We proposed 3 exceptions.
Well, Bill, let me just make my point for a
Yes.
moment. In 2011, the procedures under 49B were included within the charter, the current charter. And the Attorney General's office, the Secretary of State, all the big poobahs agreed that we could make certain amendments.
Yes.
That we could add things to 49B. One of which was the creation of an automatic charter commission.
Correct, that's
This-
nowhere authorized in
This-
statute.
This one.
Yep.
And included within that, the ability to elect people to this charter under the procedure that currently exists in the city of Concord for the election of school board members.
Correct, that was a change the state officials allowed.
Okay.
And you can make changes to 49B in a charter process that, some you can't, some you can. And that one is one that you can make. So the three that we asked for here, the first one was the number of votes by a board, the school board, required to submit a charter amendment directly to the voters. That was 7 out of the 9. And we had another provision that said if the board wants to call a charter commission, that was a 6 out of 9 vote. They did not object to that. So that's okay. That changed to 49B. There was, in addition, a section that said at least a 3/5 majority vote is required for any change to the charter, whether proposed by revision or amendment. They agreed with that. The only one they had a question about related to the percentage of voters casting ballots in the last election that's required to get a petition going to either get a revision or an amendment change. And on that one, they objected. And I must say, I'm looking forward to having Jim talk about it because I've read the state's letter a number of times. I can't quite track it. So I'm not exactly sure which part of our amendment they have objected to, but I'm interested to hear how you all feel.
Well, let Jim explain.
Jim, would you be
Illuminate.
willing to
have
offer
to?
that? Yeah.
Do I have?
Wait, so I have to tell you what they meant? Hold on.
Sorry.
Putting words in their mouth.
I struggled with it a little bit.
I think it comes down to, let me just look at this again really carefully, but I think what it comes down to is we set a threshold for amendments that was too high. That the 49B it allows you to set a high threshold for revisions, but not for amendments. We tried to maintain a high threshold for both, for good reason. They didn't like that, basically. So that part is out. We have to follow the state law because the state law does say, here are the thresholds for amendments, here are the thresholds for revisions. Because the state says it, we have to follow that. The other thresholds we set, the state said, there are no specific thresholds in the statute, so you can set your own in your charter.
So I take it, Jim, that what they're really saying is, what we were thinking of, I'm going to try to articulate it this way. We were thinking that this is okay to raise the bar within the statute, but not to lower it. And by requiring a higher percentage of the vote to amend, they view that to be inconsistent because it's too restrictive.
Yes, because they set the bar by law. That was the last amendment that happened most recently. They specifically set it in the statute, and we're stuck with that.
So
The question I have is, well, what happens if this charter never got amended? Which procedure would you be left following? And I don't know.
I'm, it seems pretty clear that we may be wrong on this one, so I just let it go.
Well, I'm wondering, we had kind of an either or. So not to be fewer than a number of voters, let's see what it was,
Not fewer than two. We had
Not-
1,000 voters and they wanted 10.
1,000. Are they they're looking to change the percentages. I get that from 20 to 15 for amendments. But are they saying anything about the other part of our change, which was
Not less than 1,000.
not less
and
than
the statute says
1,000,
not less than
whereas
10.
the statute is like not less than 10.
Yeah.
It's really a question of this. Is it likely that in any town school board election to amend the charter, fewer than 5,000 people are going to vote?
Right.
Because if 5,000 people vote, the 20% is 1,000 anyway.
Yeah.
If, the only way you'd get to 10 is only 50 people vote. That doesn't make a lot of sense.
It's probably, in answering my question, I'm guessing that while they complained expressly about the percentage, they're basically saying we object to that part of the amendment in a whole. So we basically are going to rule it. basically going to rely on
Yeah.
the RSA
We at least
49B.
ask that
Yeah.
question.
The other idea?
Yeah, I think you just stick with what just take number 2 out.
Yeah,
And that's, I've already done that, so
I got you.
I don't think this is worth
Any,
parsing out, because all of it's already in the statute, so we would just be otherwise deferring to the statute, which is the whole purpose of that amendment to that whole section of 18.
great.
Second.
That completes that, Madam Chair, the
Thank you,
discussion.
thank you. We do have number 4 on the agenda, develop the agenda for the June 14th meeting. And probably just sort of need to think chronologically through this and figure out where we are and what kinds of real final decisions we can come to.
Betty, before we
yes.
do that, can I ask something?
Well, yeah, well, go ahead.
So I do want to address Mr. Schweiker's email.
Okay. Do you want to do it right now?
Well, it relates specifically to what we have been discussing
Okay,
on the last of the 6 points.
okay. Please go ahead.
And Mr. Schweiker and I had a discussion about this before the meeting began. As I understand his argument, it is that if we are taking the position that RSA 49B now applies, that if we're taking the position that RSA 49B applies to the school district and always has, then this charter commission was improperly formed because RSA 49B, Section 4, Roman 1B requires that votes be at large. Bill and I had a long conversation about this afternoon. I think there's a decent argument that RSA 49B is not required to be adopted by the school board, but we are allowed to adopt it if we want to. But I just want to address the question of, if we are required to adopt, if our position is that we are required to adopt it, then the question was our election in violation of the statute? In order to get to that argument, you would have, in order for Mr. Schweiker to be right on that, the following would have to be true. In 2011, the Attorney General of the state, the Secretary of State of the state, the Department of Revenue Administration, all looked at the proposals that we made, or the Charter Commission made, for adoption for this procedure under the automatic Charter Commission in 10 years, and willfully allowed us to violate state law. They approved, alternatively, all of them approved the charter that we currently operate under, which includes a specific provision in that automatic charter provision section. I think it's 24, could be wrong. They all approved it. The voters of Concord approved it. And now everything that we have done is ultra-virus because we're not properly elected. I can't imagine that a court in New Hampshire would take that position. Especially because I think there is at least an argument that we don't have to do that at all, that RSA 49B is not, we're not required to follow it. So why do I raise that? Now, one of the things Mr. Schweiker said earlier, and I guess if this is the case, I'd like the proof, is that RSA 49B, Section 4, Roman 1B, was amended subsequent to the 2011 charter to change the language that required that voting be at large. And why am I raising this at all? Because Mr. Schweiker's email suggests not only that we are acting illegally and we know it, but that the lawyers on this committee are violating the Code of Professional Conduct by doing so. I've practiced law for 50 years, and I must say, the things that really get me upset are when people say, well, if you do that, you'll be violating the Code of Professional Conduct. I'm happy to say very few people have ever said that to me. But I usually say when people say that, if you think that's true, file a complaint. So, Bill, your response to my question earlier was, no, that language was part of the statute in 2011. The same
think-
language that would now be used to argue that this is illegal.
Yes, it was it was part of RSA 49B. You're allowed as a charter commission to make proposed changes to 49B. That's the bottom line. There are some that, the state officials may take a different view on. But if the state officials review your proposal, as they did in this case, of our ideas, and say, we have no objection to that, and the voters then approve it, which they did, gigantic majority did, then that's the governing rule. In this case, this charter commission considered 49B issues and did not say that that was an issue that they wanted to take head on. That's within our power as an elected charter commission to do so. It's an argument of process that is makes sense to someone who's working with legal processes all the time.
So,
For people who are not lawyers, it can sometimes be confusing.
So, if I may, though, Mr. Schweiker's email says he's not going to let this go.
That's his right.
And so if I think we ought to give Mr. Schweiker a chance to articulate clearly to us tonight
Yeah.
why it is that what we're doing is illegal and why it is that the lawyers on this committee are violating the Code of Professional Conduct.
Bill, where I was going before you brought that up was, although our agenda does not call for public input, I felt like it was important for us to recognize the people who were here today. And I guess that one of the public members has gone, but that Mr. Schweiker is here. And would you like me to invite him to speak
I would.
on a limited basis? So we'll get this cleared up once and for all. Mr. Schweiker, you've got a microphone right there, sir.
Thank you.
You're welcome.
Okay, you see, my problem is, I'm terribly confused. That at one point, you're saying, well, 49B doesn't apply, so you can retain the election by district, but at the same time, you're saying, well, it does apply, because we can't do certain things, because we have to agree with the way it is written. And I mean, to me, Mr. Ardinger half the time says, we don't have to comply with that, and the other half the time he says we do. And, I still think the correct thing to do is to allow the district's attorney to determine whether it applies to us or not, because he is, a paid individual who is going to render his, official judgment on this. And Mr. Glahn, I don't understand the rules of professional conduct, so therefore I don't know who is violating them or not. My impression would be that someone who is a paid attorney that you ask to render an opinion has got to render it properly and correctly to the best of their ability. On the other hand, someone who's elected to a charter commission who might happen to be an attorney is probably held to a lower standard. And I don't know if that's true or not. But that would be,
I certainly don't think, that is not true, but I will, but.
and so I wish you folks would tell me either, number one, it does not apply, in which case we can remove this 6 entirely and continue electing the charter commission by ward, which is what people want to do except for a couple. We had a unanimous show of hands at the meeting in April that they wanted to retain that. And if you're saying that you do not have to comply with that 49B, you can make exceptions. Let's just take out that entire number 6, keep the thresholds that are in there, and keep the election by ward. On the other hand, if you say, oh, no, we've got to do it because that's the way they say it is, then that's my basis for saying perhaps this thing is constituted incorrectly, and I don't know what the answer is. I think, as I say, the correct thing is to get a professional opinion from the attorney who seems to be best qualified to render this as to whether you have to agree to it or not, and you can go forward from there. And what really bugs me is that my understanding is that things that are not quite the correct process happen all the time in this state, and there's a process, the legislature can regularize them, and if you'd taken this up in April, when I sent the original letter, you would have had time to get it through the legislature and let them approve the commission, because you did it in good faith. So that's why I'm really upset that you didn't take this up when you had a chance. And
Well, this is an issue, I'd say this. This is an issue that Mr. Schweiker raised not in April. But
originally,
Well, there is one, I think Mr. Schweiker makes one point here, which is there an inconsistency with RSA 49B4 Roman 1B and our election of people by wards at all? However,
No.
whether there was an amendment after or before the 2011 charter, the Attorney General of New Hampshire, the Secretary of State, and the Department of Revenue Administration have all signed off on that provision in this charter, namely that we can continue to elect school board members by ward. So if it's inconsistent with the statute, their actions on that one would think that they would have said, no, you can't do that. You can't elect people by wards.
but, according to what Mr. Glahn is saying, then this commission has the option of refusing to do the number 6 is done, but leave that part of the charter as it is, so you continue to use the percentages that are in there, and you continue to elect by ward. All you've got to do is take out this thing, referring it to 49B
Not saying that at all,
instead.
Mr. Schweiker. What I'm saying is that the Attorney General of New Hampshire made the decision that the provisions for how charter commission amendments are made was contrary to the statute and suggested that we change it. He's given an opinion with respect to how ward school zone districts, I forgot what we called them, but let's call them for the sake of this conversation wards. He's given an opinion that specifically on how those members get removed if they move out of the ward. Given that, if he thought that ward voting in its entirety was illegal, one would have expected him to say so.
We're talking about ward voting for the school board and the charter commission, which are two entirely different things.
Not now.
Well, but in terms of the proposed amendment has to do with school board members who are moving out of their zone.
Ward from
Whatever.
which they're elected.
Yeah, and may I point out that the reason this is in here is because 10 years ago, nobody thought to say anything about what would happen. And so I brought it up this time around. You need to deal with it. You chose to deal with it by saying, okay, they can stay until the end of the term, which, if you want to do that, that's fine with me, even if it isn't with the Attorney General. Although I will point out you still have an inconsistency, that if someone moves out of their zone after, is it September, then they'd miss the filing period for the next election. So in effect, how do you handle that? If someone vacates the seat between October and December?
We can
Because
go through all those what ifs.
I-
And we did it that night. We spent hours and hours and hours.
and it's not in there.
I just thought it was fair to allow Mr. Schweiker to
I agree.
articulate why this was illegal and why we were violating the Code of Professional Conduct. And I think he's given us his opinion on that.
Okay. Would you like to make any comments about the work session here tonight on a limited basis? And then we need to go to our item number 4 before we can adjourn.
Okay, well, I would like to reiterate what I said about item 6, which is that it's now the opinion of the learned folks here that in fact the school district does not have to comply with 49B and stuff that's already in the charter, I would like to say, let's remove this item 6 entirely and leave it the way it is. You keep the same percentages that you already have, and you keep the election by district. But you seem to think that's okay. If they approved it once, it's still okay. So let's leave it in.
Okay, so that's your suggestion.
So that's my suggestion, and there was one other one. If you're giving me the opportunity, I was going to say something on. Oh, yes, and that's the one about appointment of school district and treasurer and whatever. I think, once again, I had the right idea the first time around, and what you're talking about is wrong. What you're going to do is leave it in the charter, saying that they will be elected. And what I suggested originally is, in fact, what they've sort of suggested here, change it to say they will be seated as determined by the school board in conjunction with state law. So if you get your representative to get the bill passed that they can be appointed instead, then they will be allowed, the school board can appoint them instead, whereas if you leave in the charter that they have to be elected, then they'll have to be elected for the next 50 years or whatever the next charter commission is.
And do you have an opinion on whether they should do financial disclosures or not?
My opinion is they should, but once again, I think you have the right idea that you can go rattle their cage about saying they aren't allowed to have it is silly, but ultimately, we need to get the legislature to approve it if that's what it takes, and let the school board do it. They seem to have the authority.
Thank you. Okay?
Thank you.
You're very welcome. Okay, back to the agenda, as stated. I will tell you, it was a little exciting around here between Friday and yesterday, because as I mentioned to a couple of folks, we thought that they had missed the 45-day deadline, but no, they made it by hours, and we were all ready to cancel this evening, because what would we do without something to which we could react? So there were an awful lot of emails and phone calls, and for once, we guessed right and didn't cancel prematurely and came out okay. Do we really need to go through each one of these items, or do we all have notes so we know clearly that we'll work through this again on June 14th? Or I will take suggestions of any kind for the agenda that night.
If I could suggest that, I think already we've talked about some language that Attorney O'Shaughnessy has put before us. If we might prevail on him
Okay.
to revise the charter with the red line against the current, so we know what changes we're proposing, and maybe have him also think about what final report language might look like, and maybe you have an idea on that already, but it would be great if before our next meeting, you were to be able to provide a draft of the new charter language, reflecting our discussion tonight, to Lyndon, and she were to distribute that to the members and to the public, that then we could look at that and read it and be prepared at our next meeting to say, this is it.
Okay, work session.
And do we, will we have the specific questions for the ballot then?
Well, that's a good question. It's fair to ask that. Maybe, Jim, if you could kind of look at the timetable here and say, what comes next in terms of the process of getting a final report and getting questions on the ballot? The form of questions and explanations.
Well, I had put out,
What?
Deadline.
22nd.
June 22nd
Yeah.
is the deadline.
Plenty of time.
I had put out to all people, if you wanted to have some input into the verbiage that would actually appear on the ballot, that we would be happy to get it by June 10th. You can do it or you can't, it doesn't, but if you do, and you want to get it gone, send it to me right off. But I have a question. Is the ballot question stated like this, do you favor, and then it goes blah, 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 blah? How is?
I think that's a question.
Okay.
I don't know yet. I mean,
Why didn't-
I haven't even started. We can phrase it any number of ways. There's no prescribed way to phrase it, but
Once you start with number one, they all go the same way.
yeah, there's like a certain way to do it. And I think what I would do is I'd look at the last ballot, and we can work on getting a copy of that and try to
It's a little different, because in there it was a revision.
Yep.
So do you support amending charter to, or to adopt that?
Yeah.
In this case, I think the way the statute says it, you say something like, do you support, vote in favor of the following amendments?
Yeah.
And then it goes, and so the language that's in our preliminary report on page 6 and 7, which has the amendment summary and then an explanation, that is going to be language that is very close to what's going to be on the ballot, subject to your review and final changes. But
And
we've
I'll-
worked hard on that language, and it's pretty darn close in my view.
And I would
But I
like
think
to,
that's the base for,
So the,
and I'd like to invite our people from this building and the school board, if you have any ideas, suggestions, this is really important to us, you know, we need your feedback too. You're very kind to come tonight, but we're gonna always ask you for one more show.
My recollection is that from past ballots, when you're dealing with constitutional amendments, the question usually is framed beginning with the word should.
yeah.
Should the
so
Should the Concord School Board Charter be amended?
Blah, blah,
X.
yeah.
So the phrasing in the statute, which I
Right.
found,
Right.
it is, each amendment shall be voted upon separately, and the question submitted to the voters in substance as follows. Remember, we talked about that phrase, in
Yeah.
substance as follows, which means it's not specifically prescribed, but you can't change it much. And this is interesting because there's two parts of this. So it can say, shall the Concord School District voters approve the charter commission, the charter amendment, and then it can either say reprinted or summarized below. I mean, that's what it literally says in the statute, reprinted, and then in parenthetical, summarized, and earlier on, it says you can present it as a summary or actually reprint the language. So I've been operating under the assumption, because of prior conversations, that we were just going to summarize, and we already have in the preliminary report two versions. Bill and I have talked about this. Like we've gone through these. Like, if I go through them anymore, they're going to really start getting bad. They're at the point where they've been overworked, right? So we think we already pretty much have that. So it's a matter of putting it together. I think that is a section of the final report that I've heard you want, so we'll put that together as, you know, draft proposed ballot questions.
Okay,
The final report needs to contain the full text of the amendments and explain the differences between the amendments and the old charter, which I think the questions do all of that. The law just lays it out there so that you don't end up just sort of being too vague. We're going overboard in explaining things, and so we're going to comply with all those requirements. It requires a legal opinion, and we need to get the state to. I've got to revise the amendments and send it back to the state, and they have to say, okay, that's fine.
Yeah.
yeah.
So
We're-
that's a part of the process we need to work on next, so that we have the green light, maybe not by the 14th, but maybe by the 14th, and if not, we need to get it pretty soon thereafter. So I've already revised,
Yeah,
and I've already revised the question, so I did that in preparation for today, so I'm already
we'll
ahead.
take whatever you have done.
It would be great before, if we can, for the 14th, we can do as much as we can do.
Yeah, we can be pretty much ready to be done. And then we'll do the same process we did in terms of getting everybody to sign it. So what did we do last, so long ago? In April, we brought a version here and people signed it here.
Yeah, all those here, that night signed it, and a couple later.
Yeah, I think we'll follow a
We
similar
could.
process.
No, okay, I just needed to make sure that we all knew why we were coming next week.
And we're trying for the meeting with the state officials, hopefully prior to next week's meeting.
Yeah,
Oh, well, I agree. Let's do it.
We're at the,
It's fun.
Can I just say one thing, because I
no,
don't want to.
we have finals.
I don't want to lose this thought. I actually think the comment about what the language could say about the clerk and treasurer isn't a bad idea to just have, look, the charter could be silent on the treasurer and clerk because we just have to follow the law. So if the law changes, then that's how the school board will determine who the next treasurer and clerk is. So you could just remove it. I mean, it doesn't have to be in there. Or it could be in there and it can say the treasurer and clerk shall be selected in accordance with applicable state law, period. I mean, they could say that.
That may make.
That's good.
That makes sense.
That's good.
And that way we're
As
not.
amended from time to time.
Yes.
We've worked hard tonight, folks.
Lyndon, Scott.
Lyndon, please.
Do you really want amended from time
Do
to
you
time?
want to add to next week's agenda that Bill Galon bring a draft of his op-ed for people's signatures and
Let's see what happens
proposal
first
of a
with-
date to
Let's try 'em.
send it to the monitor?
I'd want to see that sooner. Yeah, tomorrow.
As soon as I get my Supreme Court brief done, I'll do that.
Well, I know you have other work. We will take any kind of offers of printed material that we can look at next week. And then we will have to figure out what kinds of meetings, albeit few, that will take place after June 14th.
Can I get a motion to authorize me to forward to the state the revised charter incorporating all of the changes that resulted from the objections from the state? I just want to be able to do that and move the process along.
Before we
Before the-
see it next week?
Yeah, I mean, I just have to say, this is what it would look like with the changes. I mean,
And then we,
and then next
How
week
soon,
we're,
Jim, how soon? I mean, the answer is, I think, of course, except probably it would be better if we could see it first before,
I'll communicate with them that it's going to happen like the 15th, but we're,
Yeah, okay.
but make sure, so somewhere in this conversation, we need, the state law actually does provide language that says they really have an obligation to get back to us so that we can meet our deadline. So I'll let them know that I anticipate
It's
sending
in the
them.
process.
In process, I anticipate the changes to be adopted pursuant to their objection and to them by the 15th. If they could kindly get it back
can we
to
vote
us.
by email?
What's that?
Can we vote by email?
no.
No?
Not. I just, so if so it's not, that means they're not going to object because we're just incorporating everything
right.
they've told us to do. But that means we need to maybe reserve like another meeting on the 21st in case something happens to come in and get them.
We can deal with that next
Okay.
time.
All right. I just don't want to bring you back in here. I want to sort of move things along as much as possible.
We share that goal.
You want me to move to adjourn, Betty?
Please, did I look
I
desperate?
just did.
Okay. Is there a
Second.
second? Those in favor of adjourning?
Aye.
Aye.
Thank you all
Thank
very,
you.
very much.
Good job. Oh, would you like to, what's your schedule?